He shot most people multiple times. And as he wrote, he did this for notoriety. And he wanted to go down in history as the biggest school shooter in Michigan history. Respectfully, defendant is the rare juvenile before this court.
The Oxford school shooter wants his guilty plea withdrawn and his sentence tossed, saying there is new evidence that the court should see. Is it possible this could work? We're going to bring on former Parkland shooting judge Elizabeth Scherer, who encountered a very similar legal defense in that infamous school massacre case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. It seems the story is not over when it comes to the Oxford High School shooter, the young man who pled guilty to murder and terrorism charges for opening fire at Oxford High School back in November of 2021, injuring students and a teacher, killing 4 of his classmates. Tate Muir, 16 years old, Madison Baldwin, 17 years old, Hannah St. Juliana, 14 years old, and Justin Schilling, 17 years old. Horrific, horrific crime. Now, the shooter, who is now 18 years old, was 15 at the time of this killing spree, and he was sentenced to life in prison without the possibility of parole. Now, his parents, Jennifer and James Crumbly, they were each found guilty of involuntary manslaughter themselves. Why? For their gross failures in preventing their son from doing this. Both were sentenced to 10 to 15 years in prison. Now, you would think that that's it, right? End of the story. Well, it turns out it might not be. The shooter's appellate attorneys are arguing that his guilty plea should be thrown out and that he should be resentenced, that life without parole is not appropriate. And I will tell you, this is a very interesting argument. They are saying that the shooter has severe mental health issues, this cognitive, adaptive dysfunctions that was possibly caused by his mother drinking while pregnant with him. That was the allegation, possibly fetal alcohol syndrome. They say that the shooter didn't properly understand his rights and the ramifications of entering that guilty plea. They say this was never presented to the court. They say his trial attorneys were ineffective, that they didn't raise these issues during the plea and sentencing, and the judge was not aware of any of this, that they didn't even conduct an investigation into potential mitigating factors for sentencing. They didn't speak to the right experts. They didn't call the proper witnesses because the shooter's appellate attorneys say, guess what? We discovered there are witnesses who can testify to what the shooter was going through and that can testify to how Jennifer Crumbly was drinking while she was pregnant, that this could have affected the judge's decision, but he was not presented with this evidence. Now, you might be saying, why does this sound very familiar? And I'm going to tell you why. Do you remember the Parkland School shooting case back in 2018, Marjory Stoneman Douglas High School? 17 people lost their lives. Well, during the shooter's sentencing in that case, this fetal alcohol syndrome argument was put forward.
What do we know about Brenda's pregnancy? We know that it was very stressful and chaotic. The majority of her pregnancy, she was homeless and living on the streets. We know that she was using drugs. We know that she was smoking cigarettes. We know that she was drinking booze. Proper nutrition and proper prenatal care were not a priority for Viola. And because Nicholas was bombarded with all of those things, he was poisoned in the womb. And because of that, his brain was irretrievably broken through no fault of his own.
And with that in mind, let me bring on the person who knows this very well and can speak about this potential legal strategy. The former judge that presided over that Parkland case, Elizabeth Scherer, who's currently in private practice at Conrad and Scherer. Judge, great to see you. Thanks for coming on. So in your case, the shooter was sentenced to life in prison. That was the question of the death penalty in that case. But talk to me about what your initial impressions are with this Crumbly case.
Well, it definitely brings me back to a very similar case, like you said. I hadn't realized until I was asked to appear on your show that this defense was actually being brought forward. First and foremost, a Miller hearing, which is the type of hearing that this defendant has a right to, where a juvenile offender is being sentenced to life without parole, is very different from what I can tell than a sentencing hearing for a death penalty case. So, in other words, his right to put forth mitigation seems like it's much less inclusive than one, say, the shooter in the Parkland case who's facing death.
And that's fair, and that's 100% fair. I guess the question would be, if the judge was presented with this evidence about, again, fetal alcohol syndrome, or that his mother was, like we saw in the Parkland case, allegedly abusing substances while pregnant, that it affects the cognitive abilities of the child, their decision making. One of the arguments that was put forward in your case was that the shooter never got a fair shot. And so the argument here would be, if the judge knew about this, then maybe life in prison without the possibility of parole wouldn't have been the sentence. What is your take on this defense, this fetal alcohol syndrome related defense?
I'll first say that it's not recognized as a mental illness in the DSM, which is the leading journal or learned treatise that doctors apply diagnoses with the assistance of the DSM. It's not recognized. There's not enough information about fetal alcohol syndrome. And also, there are different levels of fetal alcohol syndrome. There is nothing that was presented in the Parkland case regarding fetal alcohol syndrome, in my opinion, that lessened the culpability of the shooter, or that would have been such a mitigating circumstance that it would have warranted a decision for life in prison. Now, whether or not the jury was thinking that along the lines of how I'm thinking, I don't know, because they don't have to give their reasons. The jury did find in favor of life for the Parkland shooter. But in my opinion, if I had to be the one that was deciding the mitigating factors, I would have given little to no weight to the mitigating factor of fetal alcohol syndrome, because of the lack of evidence supporting that particular syndrome or defense.
This is just a really sad, disturbing case, and it makes you think the world is scary. It really is. It's uncertain. And one of the scariest things that can happen to you, if you think about it, is if you get injured, right? How incredibly traumatic is that? How confusing is that? Well, that is why I want to take a minute to call out our great partner and sponsor, Morgan & Morgan. This is a firm you would want in your corner because they are specialists in this area. Morgan & Morgan is America's largest injury law firm, and for a reason. They win a lot. They have secured multi-million-dollar verdicts and settlements. In fact, they secured a $120 million verdict in one of the first personal injury trials post-pandemic. And by the way, in that case, there was a pretrial offer of just $20,000. Yeah, Morgan & Morgan, they don't settle for lowball offers. They fight to protect your legal rights and for what you deserve in compensation. But one of the best things about Morgan & Morgan is how easy they make this whole process for their clients. From starting your claim to uploading documents to signing contracts to talking to your legal team, it can all be done from your smartphone. That's it. Seeing if you have a case only takes a few minutes. Oh, and there's no upfront fee. You only pay them if you win. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar, or by dialing pound law, that's pound 529 on your phone. And this is what I want to play for you. This is sure. Judge Kwame Rowe talking to the shooter before he ultimately, and remember, the shooter took a deal, not a deal, he pled guilty. But let's take a listen to this.
Under penalty of perjury, do you swear or affirm that the statements you're about to make will be the truth?
I do, Your Honor.
Thank you. You put your hand down. What is your name?
Robert Crumbly.
And Mr. Crumbly, how old are you?
16 years old.
Can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me, the prosecutor, as well as your attorney?
Yes.
Are you satisfied with the advice your attorney is giving you? And you also have been appointed another court-appointed attorney, as well as a legal guardian ad litem. Did you have an opportunity to speak to your legal guardian ad litem?
Yes, sir.
And having spoken to your legal guardian ad litem, are you still prepared to proceed this morning?
Yes, sir.
And you're comfortable with proceeding?
Yes, sir.
You understand that you will be pleading guilty to count 1, terrorism causing death. That is a felony where you face up to life without parole, or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You may have to reimburse the government for expenses incurred from the violation. You're also charged in count 2, first degree premeditated murder. That is a felony where you face up to life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years. You understand the maximum possible penalties you face here?
Yes, sir.
You understand that the maximum possible penalty you face here on the underlying offenses is up to life in prison? And that would be life in prison without parole. You understand that?
Yes, sir.
Okay, now, Judge, that's just the sampling. There was obviously a lot
it.
more that he went into. But here's the thing about that. So the Oxford school shooter's attorneys are arguing he didn't understand. And the shooter's attorneys say he was 16 when he pled guilty. And if you look at the research and studies, it would suggest that children are susceptible to just pleading guilty without due consideration, that they don't make a thoughtful, intelligent decision. What's your take on after viewing that and that argument?
In my experience, and I don't have research to back this, but children are just the opposite. I think the juvenile offenders are more prone to take a case to trial because they don't understand the ramifications of that versus taking a plea because they're immature. If there is research to say the opposite, obviously I'm not a learned scholar in that area, but I can tell you in my experience, it's just the opposite. So what we have to understand here is when somebody enters into a plea, they have to be competent to proceed. That's totally different than having a mental illness. A person can suffer from a major mental illness, like even schizophrenia, and still be competent to proceed because they have to understand the role of the court. In other words, do you understand what the judge does? Do you understand what the prosecutor does? Do you understand if you went to trial, what rights you would have at trial, like the right to remain silent, the right to testify, the right to confront and cross-examine the witnesses who are brought against you. So the standard to be able to enter into a plea is just the ability to be able to understand the adversarial process and the adversarial nature of a trial and of a criminal complaint and the process that goes hand in hand with that. Without me knowing more, can I say whether or not he was competent to proceed? I cannot. I would assume this is judging 101. When you're going to have somebody plead guilty to a charge that could be facing the maximum penalty, that a maximum penalty could be imposed, and they perhaps have nothing to lose by going to trial. In other words, if he was found guilty, the judge would be determine whether or not he gets life without parole or, like the statute said, 25 to 40 years. So what I would be telling this individual is, do you understand that you have nothing to lose by going to trial because you are facing the maximum penalty? The maximum penalty is also the minimum penalty in this case and is essentially going to be a good portion of your life or your entire life, and you're not leaving until you're dead. And I would very, very thoroughly go into that and make that person understand before I would accept the plea. I don't know anything about this judge. I assume that this judge would make sure all of those questions were answered and make sure he was satisfied with the answers before finding that the defendant entered into a knowing, voluntary, and intelligent waiver of his rights.
Well, speaking about the judge, he has two motions to decide here. First, he's going to decide whether to hold a hearing in June of 2025. So, reportedly a year from now, right? That's when we think June 2025. Apparently, it's because his attorneys, the shooter's attorneys, and attorneys from the state, they're from the state appellate defender's office, they need time to do a comprehensive investigation. Now, if the judge withdraws the guilty plea, then we're back to square one where we either face a trial or he enters another plea. If he grants the motion to correct the sentence, then he holds what you mentioned before, a Miller hearing. It's required pre-sentencing hearing for offenders who are under 18 who face a mandatory life in prison. Then there would be a sentencing where presumably the shooter's attorneys would present all this new evidence that I mentioned about what the mother was doing and all this and his cognitive deficiencies for the judge's consideration. Now, Roe can deny both of the motions. He could maybe hold a hearing at the very least. What do you think he's going to do here with respect to either withdrawing the guilty plea or correcting the sentence?
I think it depends on, because just because the public defender who represented him initially didn't didn't present this mitigating evidence doesn't mean that they didn't present mitigating evidence. And just because they talked to certain experts, but they didn't talk to other experts, does not mean that the bottom line will change. So to me, I'm going to look at, did I consider the mitigating circumstances, and whether or not, and the Supreme Court says that a child can be sentenced to life if the child is considered permanent incorrigibility. In other words, cannot be rehabilitated. So in my mind, I'm going to be thinking, can this person be rehabilitated? Well, Jesse, all practicality, can a school shooter who premeditatedly kills 4 students, who plans it ahead of time, who draws pictures of the situation, who talks about it, can that person be rehabilitated? It would take a lot to convince me. I have never seen a school shooter that could be rehabilitated. I certainly don't think the Parkland school shooter could have ever been rehabilitated. There was just something missing in his mind that most of us, thank God, have, called remorse, called guilt, called any type of just feeling sorry for what he did. He just didn't have that. He was missing that. And I would assume that this school shooter, anyone who can carry out this type of act, is not going to be able to be rehabilitated. And I think it comes down to that. That's the bottom line.
Yeah, this is what I wanted to end it with, because if he's successful at getting a second chance at sentencing and it presents this evidence, I was curious if you thought the shooter could be successful at getting something less than life in prison without parole. But here's the thing, right? My understanding is when you talk about something like first-degree murder, it carries a mandatory life sentence in Michigan, but Judge Rowe would have the discretion to impose an indeterminate term of years instead, which I believe is what the Oxford school shooter was asking for, particularly since he was 15 when the shooting took place. Could a judge, impose a term of years when the shooter? But here's the thing, and just to add to it, could the judge do that when we can't forget the shooter requested that the judge issue the sentence that the victims' families had requested? He had said to the court, I want any sentence that they ask for. I ask that you impose it on me. I'm a really bad person. So do his attorneys say, don't pay attention to that. Don't pay attention to what he said. He doesn't know what he was saying. Is that the argument? Is that the argument then?
I mean, let me just say this. If he is a sociopath, which I would assume that he is, someone who feels no remorse, someone who does not know the difference between right and wrong, somebody who wants to be the center of attention, this could have been another play by him. Oh, look, I'm going to fall on my sword. I'm going to show remorse. I'm going to pretend to have remorse. And I'm going to say I want whatever the victims' families want. And then after he sits behind bars for a few years, he thinks, oh, maybe this wasn't such a good idea. Or maybe this isn't working. Maybe they're not going to have mercy on me like I thought. Maybe I'm not in the spotlight anymore. So this is not, maybe what I wanted to do. I mean, I don't really know, but you're right. In the scheme of things, even if there is a resentencing, even if the judge reverses himself and sentences him to a period of years to be revisited at a later time, is another judge in 40 or 50 years going to let him out? I mean, I wouldn't.
Judge Elizabeth Scherer, thank you so much for your perspective. I was really happy to have you on because you have this kind of unique insight into it, and clearly this connection to, unfortunately, another school shooting case. But we'll continue to follow. It's really interesting arguments. But Judge Scherer, thank you so much for coming on, as always.
Thank you.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.